Good morning, everybody. வணக்கம் எல்லாருக்கும். இங்கு இணைந்திருக்கிற அனைத்து உறவுகளுக்கும் மேலும் எம்மோடு இன்று இந்த நிகழ்வில் கலந்து கொண்டு முக்கியமான விடயங்கள், அதாவது ஈழத் தமிழர்களின் சுயநிர்ணய உரிமை பற்றிய விவரங்களை நிபுணர்கள் மூலம், சட்ட வல்லுநர்கள் மூலம் அறிந்து கொள்வதற்காக இன்று நம்மோடு இணைந்திருக்கும் பேச்சாளர்களான மாண்புமிகு ருத்ரகுமாரன், நாடு கடந்த தமிழீழ அரசாங்கம் பிரதமர், மற்றும் ஆல்ஃபிரட் டிசையர்ஸ், அவருடன் டாக்டர் லிவிங்ஸ்டன் ஃப்ரம் உகாண்டா, மற்றும் நம்மோடு இன்று இந்த விடயத்தை பற்றி பேசுவதற்காக பிரபல சட்ட வல்லுநர் கனடா வினிபெக்கில் இருந்து மிஸ்டர் டேவிட் மேட்டர்ஸ் இணைந்திருக்கின்றார். அவர் மட்டுமல்ல, இங்கு பல சட்ட வல்லுநர்கள் இணைந்திருக்கின்றார்கள். அந்த வகையில் இலங்கை, இந்தியா, ஐரோப்பா, மலேசியா, தாய்லாந்து மற்றும் ஏனைய பல இடங்களிலிருந்து இன்று பல உறவுகள் இணைந்திருக்கின்றார்கள். அந்த வகையில் எல்லோரையும் வரவேற்றுக் கொண்டு நாம் வழமை போல இந்த நிகழ்வை ஆரம்பிப்பதற்கு முன்பு பூர்வீக குடி, கனடிய பூர்வீக குடி மக்களுக்கான மரியாதை மற்றும் அகவணக்கம் போன்றவற்றை நிறைவு செய்து கொண்டு இந்த நிகழ்வை ஆரம்பிக்கலாம் என்ற வகையில் இப்பொழுது சாரதி ரமேஷ் அவர்கள் தொகுப்பாளர், அவர்களை அழைக்கின்றேன்.
Thank you, Vimal. Hello.
You have to unmute yourself.
Are you able to hear me now?
Yes, please.
All right, perfect. Good morning, everyone. My name is Sharathi Ramesh, and I will be our host for today. I'm a fourth-year undergraduate student at the University of Toronto for Evolutionary Anthropology and Sociology of Genocide. Welcome to our discussion today about Eelam Tamil's right to self-determination. We are going to be joined with various professionals, bringing together leading scholars and practitioners of international law. And before we begin, I would like to give a land acknowledgement. We would like to begin by acknowledging the land on which we gather, and which the region of Peel operates, is part of the treaty lands and the territory of the Mississaugas of the Credit First Nations. For thousands of years, Indigenous peoples inhabited and cared for this land, and continue to do so today. In particular, we acknowledge the territory of the Anishinaabeg, Huron-Wendat, Haudenosaunee, and the Ojibwe-Chippewa peoples, the land that is home to the Métis, and most recently, the territory of the Mississaugas of the Credit First Nation, who are direct descendants of the Mississaugas of the Credit. We are grateful to have this opportunity to work on this land, and by doing so, give our respect to its first inhabitants. Next on our agenda, we will be having a moment of silence as directed by Vimal.
இப்பொழுது நமது நிகழ்வை ஆரம்பிப்பதற்கு முன்பாக அகவணக்கம் ஒன்றை கூறிக்கொண்டு ஆரம்பிப்போம் என்று தாழ்மையாக கேட்டுக்கொள்கிறேன். அந்த வகையில் தமிழீழ விடுதலை போராட்டத்தில் வீரசாவடைந்த அனைத்து மாவீரர்களையும், ஸ்ரீலங்கா இந்திய படைகளாலும் இரண்டகர்களாலும் படுகொலை செய்யப்பட்ட மக்களையும், நாட்டு பெற்றாளர்களையும் மாமனிதர்களையும் நினைவு கூறுவோமாக. நன்றி. நிறைவு செய்வோமாக. Shardi.
Thank you all for that moment of silence in honor of our Tamil freedom fighters. Now I would like to get on with our introduction for today's event. I will be directing it in English as we're speaking to an international audience, and Vimal will be doing the Tamil portion of it. But before we even begin that, I would first like to give a content trigger warning. As there may be brief mention of sexual assault, violence, gore, or other mature content. Some of our audience may be survivors of war or assault, or they may be minors. So I ask that you keep in mind your mental well-being throughout the discussion, please. Viewers' discretion is advised. And I also highly suggest that viewers take notes of the discussion we have today, as we will be having a discussion question and answer period. We have some amazing speakers here, influential figures who specialize in what they bring to the table. And what we have to say is very valuable knowledge in all aspects of foreign policy, classification, and prevention of genocide, and an international perspective from the viewpoint of different people around the world. We're really getting a global perspective here. So I really hope that we are able to continue this online discussion and be open to everyone's different viewpoints and perspectives. So today's discussion will be covering the questions along the lines of: when can people declare independence? What is remedial succession, and when may it be applied? What lessons can the genocide of Palestine, East Timor, and Western Sahara teach us about the Eelam Tamil crisis? Where is the similarities and the differences, and what patterns can we deduce from these? Bringing together leading scholars and practitioners of international law, this panel will examine issues of external self-determination and remedial succession in the context of Eelam Tamil's conflicts, specifically the Tamil genocide within Sri Lanka committed by the Sri Lankan state. The goal would be to place the Eelam Tamil's issue in comparative perspectives and survey the state of international law and practice at present on cases of remedial succession. With that being said, I will pass over the introduction to Bima.
நன்றி செல்வி சாரதி ரமேஷ். இன்றைய நிகழ்வானது ஈழத்தமிழர்களின் சுயநிர்ணயம், மறுசீரமைப்பு பிரிவினை மற்றும் சர்வதேச சட்டம் ஆகியவற்றின் ஒப்பீட்டு கண்ணோட்டத்தில் ஈழத்தமிழர்களின் நெருக்கடி தொடர்பில் ஐநாவின் முன்னாள் மற்றும் இந்நாள் மக்களாட்சி மற்றும் சமத்துவ பன்னாட்டு நிலையை பிறப்பும் தற்சார்பு வல்லுநர்களோடும் மற்றும் எமது 2009 மே 18ஆம் தேதிக்கு பிற்பாடு புலம்பெயர் தேசத்தில் நாடு கடந்த தமிழீழ அரசு நிறுவப்பட்டு அதன் பிரதமராக நீண்ட காலமாக செயலாற்றி வரும் பிரதமர் ருத்ரகுமாரன் விஸ்வநாதன் அவர்களை இங்கு வரவேற்க விரும்புகின்றேன். இவர்கள் எல்லோரும் இந்த ஈழத்தமிழரின் சுயநிர்ணயம் மற்றும் அவர்களது உள்ளக சுயநிர்ணய உரிமை மூலம் எப்படி அந்த ஈழத்தில் நாம் விடுதலை பெற்றுக் கொள்ளலாம், இதனை எப்படி நாம் சர்வதேசத்திடம் அணுகி சரியான முறையில் எமக்கான விடுதலையை நாம் பெற முடியும் என்பது பற்றிய விவரங்களை இன்று பரிமாறுவார்கள். இந்த நிகழ்வானது ஒருங்கமைக்கப்பட்டதற்கான காரணம், பல காலமாக ஈழத்தமிழரின் சுயநிர்ணயம் பற்றி நாம் பேசி வருகின்றோம். அந்த வகையில் இதை சரியான வழிகாட்டல்களுடன் இங்கு இணைந்திருக்கக்கூடிய வல்லுநர்களின் ஆலோசனைகளை கேட்டு நாம் எப்படி இதை முன்னெடுத்து செல்லலாம் என்பதை பற்றி அறிவதற்காகவே இந்த நிகழ்வு ஒழுங்கமைக்கப்பட்டது. அந்த வகையில் இது நாங்கள் இப்பொழுது செய்கிற ஒரு விடயம் அல்ல. இது பல காலமாக பல அமைப்புகளும் பல செயற்பாட்டாளர்களும் முயற்சித்து வருகின்ற ஒரு முயற்சியே. இன்றைய நிகழ்வானதன் முக்கிய நோக்கம், இன்று நாம் அனைத்து முக்கியமான நுணுக்கமான உரையாடல்களுக்கு இணைந்திருக்கின்ற அனைத்து சர்வதேச வல்லுநர்களும் சட்ட வல்லுநர்களும் எம்மை வழிநடத்துவார்கள் என்று நாம் எதிர்பார்க்கின்றோம். அந்த வகையில் எல்லோரையும் வரவேற்றுக் கொண்டு தொடர்ந்து இந்த நிகழ்வை முன்னெடுத்து செல்வதற்கு செல்வி சாரதி ரமேஷ் அவர்களிடம் கையளிக்கின்றேன். எல்லோரையும் வருக என்று வரவேற்றுக் கொண்டு வாழ்த்தி சாரதி அவர்களை தொடருமாறு கேட்டுக்கொள்கின்றேன். நன்றி.
Thank you, Vimal, for the introduction. And now, ladies and gentlemen, we are going to be moving on to our panelists for this morning. Starting off, I would like to introduce us all to Dr. Livingstone Siwenyana. So he is an independent expert on the promotion of democratic and equitable international order. Dr. Livingstone is a recipient of several awards of his scholarly and professional work, the most recent being the Regional CEO Award of 2017 and the NACOBA Service Award of 2016, the European Union Human Rights Defender Award of 2015, the Shanti K. Kinduka Award of Social Development in 2013, the African Human Rights Defenders Award of 2013, and Outstanding Young Alumnus Award of 2006. We are having the absolute pleasure of having Dr. Livingstone here and having his support for Eelam Tamils, and I would like to give the floor over to him if he is prepared.
Good. Dr. Livingstone.
He's trying to connecting. He was there, but he had some connection issue. Yeah, it's okay now.
Okay, now can you unmute him? I think we only see his video. There's no microphone for him.
Doctor, you have to. You have to. Yes. Your audio, please.
Yeah, there's no audio for Dr. Livingstone.
You have to active your audio on your left side. Okay, you can go to other speaker, then he will be next.
No, there's an order, so I want him to. Are you on the phone with him, Bospa?
I was on phone with him, so just to hear.
But maybe he's not aware because he's not going to listen or hear what we are saying if he has
No, I already cut the phone, but now he's connected, but just we have to wait.
மன்னிக்க வேண்டும் எங்களுடைய முக்கியமான ஒரு பேச்சாளரின் Zoom.
But, doctor, you have to just on your left side down. You have to on your mic.
Yeah, but he's not going to hear unless you're talking to him on the phone. He's not going to hear because there's no audio.
No, I'm not talking on phone. I'm just talking on.
That's what I'm saying. But if you're talking on the
yeah, now it's okay now.
Good. Shardi, you want to reintroduce him? He might have not heard you.
Oh, for sure.
Sure.
So sorry about that, folks. We were having technical difficulties, but now that they have been resolved, hopefully, I'm going to reintroduce Dr. Livingstone Siwenyana. He is an independent expert on the promotion of democratic and equitable international order. Dr. Livingstone is the recipient of several awards for his scholarly and professional work, the most recent being the Regional CEO Award of 2017, the NACOBA Service Award of 2016, the European Union Human Rights Defender Award of 2015, the Shanti K. Kunduka Award for Social Development of 2013, the African Human Rights Defenders Award of 2013, and the Outstanding Young Alumnus Award 2006. Dr. Livingstone, we are very pleased to have you here and speaking with us and giving your support to the Tamil community, and we invite you to the floor now.
Dr. Livingstone, I think you have to set up your audio before you talk. We cannot hear you. Dr. Livingstone? I think he has muted. make him a host so that he can unmute by himself.
No problem.
Mandikawandam, sila technical difficulty. Dr. Livingstone is joining from Uganda. Make him a host if you don't mind. Dr. Livingstone, can you talk? So if not, then we're going to go move forward with.
Okay, are you hearing me now?
Yes, we are.
Yeah.
Okay, that's great now. Sorry about the technical difficulties. Yeah, thank you so much for the opportunity once again. I am delighted to join the discussion today. As you recall, the subject of self-determination is a very important one. It is about rights. When a people are oppressed, they have a right to assert themselves. And as we all know, part of that process requires them not only to speak out, but where appropriate, to ensure that all necessary steps are taken for them to be recognized as a people. And when they are under threat, international law does allow them to even exercise their right to independence. We have seen that in some other countries, for example, among the Eritreans, when they were under oppression from the Ethiopians, they were able to assert themselves, and with UN support, they were able to create their own state of Eritrea to assert their rights. So the people in Sri Lanka, particularly the Tamils, are facing a very precarious situation. They have been under oppression for long. The UN has picked up this issue. There have been various missions to Sri Lanka, and all of them do affirm the fact that the Tamils rights have been abused. They are facing decimation, and they need to exercise their rights to self-determination. They need independence from those who are subjecting them to untold horror. And as such, it is important that the world unites in this very important mission, that the Tamils should not be seen to be completely decimated, for the world to step up its efforts. That's why we, within our mandate, we are our unqualified, wherever it is, to join them in making a case. And it is in this respect that all discussions, all efforts directed at reasserting themselves is actually appreciated. We hope through this discussion, we shall be able to share comparative experiences, particularly when brother, the former UN independent expert on promoting a democratic and equitable international order, Alfred, speaks. He'll share with us some comparative experiences, how this has been achieved elsewhere. How can the peoples in other places other than Sri Lanka also assert themselves? The people of Yemen, those in South Cameroon, those in Japan, who are facing similar experiences, how can they assert themselves? This is important, not only for the people concerned, but the rights movement as a whole. Humanity as a whole needs to be rescued from persecution or persecution wherever they are. And it is in this regard that we support all efforts and join this discussion today. So thank you very much. I look forward to hearing from my brother Alfred Zayas about comparative experiences and how best within the UN this effort can be supported. Thank you.
Thank you, Dr. Livingstone, for that amazing analysis. We are very grateful to have you here with us, and we are very fortunate to get to hear from you today. Now, I would like to move on to our next panelist, which is Visuvanathan Rujakumaran. Mr. Rujakumaran is currently heading the transnational government of Tamil Eelam as its prime minister. He studied at Jaffna Central College and earned law degrees from the Colombo Law College and Southern Methodist University. He also studied law for a period at Harvard and is an expert in immigration law. Mr. Rujakumaran, we now like to welcome you over to our stage and thank you for being here. The floor is yours, sir.
Can you hear me now?
Yes, we can.
Yes.
Okay, good. We hold in reference the sacred memories of our Mahavirar who sacrificed their lives for the realization of the Tamils' inherent right to self-determination in the form of an independent and sovereign state of Tamil Eelam. The Mahavirar who gave their lives for remedial cessation as a last resort in order to ensure the very physical survival of the Tamil people. As Judge Aman said in Barcelona Tructon case, that the norm of self-determination is imbued with natural justice, humanity, and human ideals, and also morality. If I may paraphrase President Woodrow Wilson, self-determination is not a mere phrase, it is an imperative principle of action which statesmen ignore at their peril. Self-determination is a collective self-expression. Self-determination allows people to write their own history. Self-determination allows people to charter their own course of action. Article 1 of the Civil and Political Rights Covenant, Article 1 of the Economic and Social Rights Covenant say that the realization of the right to self-determination is a prerequisite for the enjoyment of all other rights. In other words, the right to self-determination is a mother of all other rights. So the question now arises, who is the legitimate recipient unit of the right to self-determination? Who can exercise the right to self-determination? According to the covenants, the people have the right to self-determination. How do you define people? If you look at the International Court of Justice opinions in the Western Sahara, in the Namibia case, and also writings of eminent scholars, which is also considered as a source of international law, we can identify three factors, three elements that constitute people. Number one, that particular entity should have some objective characteristic. Objective characteristics such as distinct language, distinct culture, distinct religion, etc. Then they also identify some subjective factors. Subjective factors such as sense of solidarity, the lasting will, real determination, conscious action, concerted words. These are all just not my words. These are the words used by Judge Aman in the Western Sahara case. So you have all these facts that pertains to the subjective element of the of people. Then the third one, they identified that this particular group should have a relationship to a defined territory. With respect to the Eelam Tamils, the fact that we have a relationship with the northeastern part of the island of Sri Lanka has been recognized not only in domestic agreements, but also most importantly in international agreement. You take it Banda Chelva Pact, you take it Dudley Chelva Pact, both pacts recognize that the northeastern part of the island of Sri Lanka is inhabited by Tamils. But as I said earlier, most importantly, the Indo-Sri Lankan Accord, an international agreement, recognize that the northern and eastern province of Sri Lanka are historically inhabited by Tamil-speaking people. So we have objective characteristics, we have the subjective element, we have the relationship to a defined territory. So under international law, we constitute people who are entitled to the right to self-determination. I think even the Sri Lankan Supreme Court, in a way, implicitly recognized that the Tamils constitute people. When an action was brought against the TNA, when the TNA called for federalism, I think some single organization brought an action in the Sri Lankan Supreme Court arguing that the TNA's call for federalism is in violation of the 6th Amendment to the Sri Lankan Constitution, which criminalized even peaceful advocacy of the right to self-determination, even peaceful advocacy for a cessation in violation of freedom of speech, freedom of association, etc. I don't want to go into or go about that at the moment. But what the action was brought in the Supreme Court saying that the TNA's call for federalism is in violation of the 6th Amendment. The Sri Lankan Supreme Court said, no, what they are asking is not just a federalism. It is just an internal self-determination. It is not external self-determination. Therefore, it is not a violation of the 6th Amendment to the Constitution. So whether it's an internal self-determination or whether it is external self-determination, the recipient unit should be the people. Minorities cannot have internal self-determination. So I would argue implicitly, even the Sri Lankan Supreme Court has recognized that the Tamils constitute people who are entitled to the right to self-determination. Now let's come to the subject of today's discussion. Under what circumstances this right to self-determination can be exercised externally? Under what circumstances this right to self-determination can be exercised in the form of remedial cessation? If you look at the state practice, now before I go to the state practice, I think the main declaration pertains to self-determination in the non-colonial context is General Assembly Resolution 26/2025, the friendly relation among states, which is considered as customary international law. It was promulgated after 7 years of deliberation, taking into account various points of view from various factors, various countries. So 26/25 is the main declaration, the main document we rely to advance our case. So 26/25, the main paragraph 7 of 26/25, it says, nothing in the foregoing paragraphs shall be construed as authorizing or encouraging any action which would dismember or impair totally or in part the territorial integrity or political unity of sovereign and independent states conducting themselves in compliance with the principle of equal rights and self-determination of people as described above. And thus, these are the important lines. And thus possessed of a government representing the whole people belonging to the territory without distinction as to race, creed, or color. This is the main paragraph of the 26/25, which, as I mentioned earlier, which is because the General Assembly does not have the lawmaking capacity. However, this particular paragraph is considered as part of customary international law. When you look at the state practice, the origin of remedial cessation, the origin of external self-determination, we can trace to Ireland Island. In the 1800, the Soviet Union defeated Sweden and annexed Finland and Ireland Islands. In 1917, following the revolution, the Russian Revolution, Finland declared independence. And the Ireland Island is primarily inhabited by Swedish origin. So the question arose whether Ireland Island should be part of Finland or the Ireland Island should be allowed to be united with Sweden. So Ireland Island people, they held a plebiscite referendum. 90% of the people voted for to be united with Sweden. Finland said, no, this is part of our territory. You are subject to our jurisdiction. You cannot join the Sweden. Then Finland, like other oppressor state, sent the troops, arrested people who held the referendum. So interestingly, it was the Great Britain. The Great Britain invoked Article 10 of the League of Nations and said, well, this conflict, this dispute constitutes a threat to international peace and security of good relations among states. And Great Britain referred the matter to the League of Nations. That was the predecessor of the United Nations. So the League of Nations appointed two committees. One is a commission of jurists, the other one commission of rapporteurs. So the first question that was put to the commission of jurists was whether the Island remains within the domestic jurisdiction of Finland, or it falls within the international sphere and comes under the League of Nations. So at that time, the commission of jurists dismissed the idea of self-determination, because at that time, self-determination did not evolve into a legal right. It was kind of a principle, but so they did not go in detail. However, they said, because at that time, the Finland was acquired the character of definitive constitutive state. Finland was in the formation of a state. It has not yet become a state. Therefore, the matter falls within the sphere of influence of League of Nations. But what is important? What is important? What I want to point out: the Commission of Jurists, even though the question of remedial cessation was not put to the Commission of Jurists, they said that whether when a group of people subjected to the manifest and continuing abuse of sovereign power to the detriment of that group would become an international dispute. So what they are saying is, when a group is subjected to human rights violation, then that matter falls within the sphere of influence of the international organization, the League of Nations. Then the commission of the rapporteurs, international rapporteurs, they took a different point of view. They said, no, Sweden is well established, so this matter falls within the domestic jurisdiction of Finland. However, they said, when a state lacks the will or the power to enact and apply just guarantees, then that matter falls within the sphere of influence or international sphere of influence. So when a state, the host state or oppressor state, when they lack the power or the will to enact just guarantees, then that matter falls within the international sphere of influence. And this is not directly related to our remedial session question, but I would like to just to share with you the guarantees, the proposals put forward by the Commission of Rapporteurs for the Island to remain in Finland. They put forward four guarantees. First, they said that the Finnish province, in the island, the primary and technical schools should provide instruction only in Swedish language. That should be the first condition they put forward. Then they said that islanders be accorded the right to preemption on every occasion when offers to purchase lands were made by outsiders. They should have the preemptive right. And then the 13th Amendment or even the Chandrika's proposal, we don't have any proposal like that. And the third one, they said, newly arrived settlers be granted franchise only after stay of 5 years. This is other things we always talk about, the critical date, because now we are going to have a referendum whether people who are being colonized, can they vote? So that as I had talked earlier, there's a concept called critical date. Then we will talk at some other time. Okay, whether they should be 5 years or 10 years or 15 years. That's other matter that we'll talk when they agree for the plebiscite, for a referendum, and when we talk about the technicalities, we talk about that. So then finally what happened? Then the Finland government agreed to guarantee to provide those guarantees, and they settled the matter. Then the question of remedial cessation arose in Kantaka, in the Democratic Republic of Congo. In Zaire, the Kantaka people, the People Congress of Kantaka, they made a complaint to the African Commission of Human and People's Rights, saying that their right to self-determination had been violated. So the commission said, in the absence of concrete evidence of violations of human rights, and in the absence of evidence that the people of Kantaka are denied the right to participate in the government, they cannot claim self-determination. So they put two factors. First, there should be a human rights violation. When abuse is systematic, pervasive human rights violation. The other thing, there should be a denial of participation in the governance by those people. If you don't have those two things, then you cannot invoke the right to self-determination externally or the remedial cessation. Then following that, in 1996, this issue came in the Europe before the European Court of Human Rights. There, what happened, you know, the Northern Cyprus is under the occupation of Turkey. So a Greek citizen took an action, brought an action in the European Court of Human Rights, saying that the Turkish occupation violated her property rights. The remedial cessation was not the question put to the European Court. The question was whether there is a violation of property rights. But one of the judges, he gave in a concurring opinion, he said, if an entity's human rights are consistently and flagrantly violated, or if they are massively underrepresented in the governance, then they have a right to establish an independent state. So again, they identify two factors. There should be abuse, there should be violation, massive violation of human rights, and the denial of effective participation in the political process in the governance. If you meet those two criteria, two factors, then you have a right to establish your independent state. Then we come to Quebec thing. You all know about the Quebec case 1996. The Supreme Court said, Canadian Supreme Court explicitly said that because there's an argument put forward by us in some quarters that the right to self-determination only falls within only belongs to the colonial people and not in a non-colonial people. But the Canadian Supreme Court explicitly stated, no, actually citing the resolution 2625 and stated, right to self-determination is applicable even in a non-colonial situation, and the Quebec people have the right to self-determination. I don't know whether they said the Quebec people have the right to self-determination, but they said the self-determination is applicable in non-colonial context. And then they identified three criteria under which you can exercise the right to self-determination in the external. First, they say the colonial people can exercise the right to self-determination externally. That's, as I said, there's no one dispute that. The second thing they said that when a group of people are subject to alien domination or occupation, then they also have the right to, they also can exercise the right to self-determination in the external form. And thirdly, they said, when the group is not represented in the political process, it's not in the governance, then that group can also exercise the right to self-determination. This opinion came, I think, 96 or 98, but I must say, during that time, probably most of the Canadian people might know there was a big case was going on, the Suresh Manikavasam case. Suresh Manikavasam case is the Canadian government tried to deport Mr. Suresh Manikavasam under the special proceedings 40.1, saying that he was involved in an act of terrorism, quote unquote, that he was collecting money for the liberation tigers of Tamil Eelam. So that case went for nearly, I think, maybe 40 or 50 days. And experts from all across the globe came and testified. Professor Boyle came and testified, Karen Parker testified, Alfred Rubin testified, a lot of professors came and testified. And we took the position, LTT took the same position articulated by the Canadian Supreme Court subsequently. We took the position that's enough, that we are people entitled to the right to self-determination. We are fighting to establish an independent state of Tamil Eelam. And if there are any problems, you cannot bring us under this domestic law of terrorism. You can charge us, maybe saying the violation of war crimes or crimes against humanity, but not under the purview of terrorism laws. But anyhow, the the federal court say no, that the domestic law prevails, and then they issue a deportation order. But I must say that still Mr. Manikavasam in Canada. Canada couldn't deport him. He's still in Canada because he got relief under the Convention Against Torture. So that's other thing. So anyway, so when we finished, then 1996, I think the Canadian Supreme Court came. Then this issue, the issue of remedial cessation again arose in 2003 with respect to Cameroon. Southern Cameroon argued the same issue before the African Commission on Human and Political Rights, saying that their right to self-determination had been violated. Here again, the African Commission, they reiterated, they reaffirmed the Kantanka position, and they said, when people are subject to concrete human rights violations, coupled with the denial of their right to participate meaningfully in the political process, then they have a right to a remedial cessation. They can establish an independent state. This again, they said they reaffirmed their position, which they took in the Kantanka case. Then we come to the Kosovo case. Kosovo case is, I think, 2011, the ICJ rendered an opinion. But the ICJ, the question that was put to the ICJ was a very narrow question. The question was that they have sought advisory opinion whether unilateral declaration of independence by Kosovo is contrary to international law. That's the only question. The question didn't even say whether it is in accordance with international law. They didn't say that was not the question. The question was whether it was contrary to international law. And the International Court of Justice said no, because in international law, the unilateral declaration is neither legal nor illegal. That's what as it stands now. But then one of the judges, Judge Yusuf, he elaborated on that. He said, when a state denies the exercise of the right to self-determination and subjects that particular entity to human rights violation, then that entity can exercise their right to self-determination in external form or remedial cessation. So again, so if you distill from all these decisions, there are two factors. That if an entity is subject to massive human rights violation, if an entity is denied meaningful participation in the political process, then of course that entity has a right to self-determination. So in the Kosovo case, the ICJ invited member states to file briefs to state their positions. 40 states filed briefs. Out of 12 states, including Russia, Germany, Netherlands, they took a position that the remedial cessation is there, that an oppressed group of people can invoke the right to self-determination in external form as a remedial manner, as a remedial cessation. So now we take these two factors and trying to juxtapose to the Tamil situation. The human rights violations of the Tamils are well documented. I don't think we have to talk about that. From 1957 to 2006, there have been documented 157 racial pogroms documented by the Northeastern Secretary, LTT's Human Rights Secretariat. In 2006, they documented that one. From 1957 until 2008 or 2006, there were 157 racial pogroms. Then what happened in 2009, we all know. What's that? According to the expert panel report, you had credible evidence, 40,000 civilians got killed. According to the internal review report, there are credible evidence, 70,000 people got killed. But the numbers, that doesn't matter, because if you look at the Srebrenica genocide case, only 8,000 people got killed. Only 8,000 people got killed, and the ICJ said that constitutes an act of genocide. So here also we have overwhelming evidence that we have been subject to massive human rights violations since independence. Then the other question, whether the political participation, whether we have a meaningful participation in the political process, starting from the 1956 Single-Only Act, the 1972 Constitution, the 1978 Constitution. All these acts, all these constitutions were imposed on our head. They were passed over our head. We didn't matter, and we still don't matter in the political process. Even if there are two Sinhala parties, when the issue comes between Tamil and Sinhala, both parties get together. In Sri Lanka, the numerical majority always constitutes a political majority due to racism. We don't have any say in the political process. We elect our MPs. What can they do? They can simply go and talk in the parliament. They cannot simply even block a single legislation. In fact, the expert panel, they recognize that. In their expert panel report, if you look at it, they're saying the root cause of the conflict is a perceived or real exclusion of the Tamils. It is not a perceived exclusion, it's a real exclusion of the Tamils. We don't matter at all in the Sri Lankan political process. So we are denied effective political participation. We are subjected to massive human rights violation. We have every right to establish an independent state. We have a compelling case legally to establish that we have a right to establish an independent state under the remedial cessation. But I must tell you, these are the question of cessation, the question of remedial cessation, external self-determination. These all are political questions. Legal considerations play a role, but they are not determinative. It's been determined by political consideration. That is the fact of the matter. Recently, I attended a webinar on the issue of Satak, there's an enclave in Azerbaijan. You would have heard about that. There was a war maybe a year ago, 2 years ago. It was inhabited by Armenians, and Azerbaijan people took it by force. So there was a webinar, and some eminent scholars participated. I attended that webinar. And Professor Jeffrey Robertson, he's a professor from UCLA, and he was a former UN political affairs officer. He said, for an independent struggle to be won, 4 conditions need to be met. First, he said that the interest of the entity that calls for an independent state should align with the interest of a big power. That's the first condition, he said. The second condition, he said, our claim should be consistent with internal prevailing norms. And the third condition, he said, our claim should have the support of the NGOs, international NGOs. And the fourth condition, he said, that the oppressor state should be politically and economically weak. Brothers and sisters, the conditions are moving in that direction. Let's expedite that process by employing all our political, legal, and economic tools at our disposal. The Tamils' destiny is in Tamils' hands. The thirst of Tamils is Tamil Eelam. Thank you.
Thank you so much. பிரதமர் உருத்திரகுமாரன் அவர்களுக்கு நன்றி கூறிக்கொள்கிறேன். அந்த வகையில் நிறைய ஏனைய நாடுகள், அதாவது சுய நிர்ணய உரிமை கோரும் ஏனைய நாடுகளின் உதாரணங்கள் பல இங்க குறிப்பிட்டிருந்தார். அந்த வகையில் இந்த நிகழ்வின் இறுதியில் நம்மோடு ராதிகா சித்சபை ஈசன் அவர்கள் இணைந்திருக்கின்றார்கள். அவர்கள் நீங்கள் கூறியதை சுருக்கமாக சமரைஸ் பண்ணுவா. அது வரைக்கும் நான் இப்பொழுது சாரதி அவர்களிடம் கையளிக்கின்றேன். மறுபடியும் வாழ்த்துக்கள் பிரதமர் உருத்திரகுமாரன் அவர்களுக்கு. சாரதி.
Thank you so much for that lovely and very insightful discussion. For that, it was more so like a mini lecture, and I really found that very insightful. Thank you so much for that. Truly, we need more people to discuss the facts and examples of such remedial successions like this, because it really does open the eyes to young people like myself about these studies of genocide that we are embarking upon. Really, we have to be looking upon these examples and seeing what we can do in light of the events that have already happened, and how we can sort of piggyback off of that in order to get to our own result of the cause that we are really researching upon. So thank you for that, Prime Minister Rudra Kumaran. Next up, I have the absolute pleasure of introducing Mr. Alfred Maurice de Zayas. He is the first UN independent expert on the promotion of democratic and equitable international order from May 1st, 2012 to April 30th, 2018. Professor de Zayas served as the first UN independent expert on the promotion of democratic, equitable international order, and he is a visiting professor of law at numerous universities, including the University of British Columbia in Canada, the Graduate Institute of the University of Geneva, the DePaul University Law School of Chicago, the Human Rights Institute at the Irish National University of Galway, and the University of Trier in Germany. At present, he teaches international law at the Geneva School of Diplomacy. Professor de Zayas has been a constant supporter of Eelam Tamil rights and has been gracing us with all of his knowledge on Human Rights Declaration, as well as the self-determination of Tamil rights. He is an avid supporter, and we are truly grateful to have you here, Professor. I pass the floor over to you.
Hi, Sharuti. First of all, thank you for the invitation. And let me salute our friends Wimmel and Livingstone and Abirami. I surely endorse everything that has been said by the previous speakers, and very happy that there's been reference to General Assembly Resolution 2625, which, by the way, is reflected in so many other United Nations resolutions and in the Vienna Convention, or rather Vienna Declaration and Program of Action of 1993. Now, the focus has been very much, as indeed in the invitation, on the concept of remedial secession. Now, there's no question that the Tamils have the right of remedial secession, but, and that is a problem with international law in general, it is not self-executing. It is not automatic. The fact that you have a right, the fact that that right is anchored in the UN Charter, that right is very much the essence of the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, Article 1. I mean, that doesn't mean you're going to get it. It is mostly a political matter. Now, who has gotten it? Who has invoked remedial secession? Well, Kosovo got it, and Eritrea got it, and Timor-Leste got it. But who didn't get it and had also very strong arguments of remedial secession? Well, if you remember well, in the course of the decolonization of the Indian subcontinent, the Kashmiris have been subjected to such crimes against humanity for decades, notwithstanding Security Council Resolution 47, nothing. If the major powers do not support it, you don't get it. Who didn't get it either? We've had a couple of cases from Africa mentioned here, Southern Cameroon and Congo, etc. Look, much worse, many times worse, was the genocide against the Igbos and the Ogonis of Biafra. That was the Nigerian civil war of 1967 to 1970. 2 million dead, something horrendous. But Royal Shell had enormous oil interest in Biafra, and nobody supported the human rights of these Ogonis and Igbos. They were just massacred and nobody cared. Look at the Palestinians. Look at the boobies of the island of Fernando Po, which is the island of Bioko. It was artificially joined with Equatorial Guinea. There are different ethnic groups that have nothing to do with Equatorial Guinea. When Spain decided to release them into independence, instead of releasing them separately, here is one colony, Bioko, here's another colony, Equatorial Guinea, and they both emerge in self-determination. Now, they join them together. So the poor boobies exchange the colonial power, which used to be Spain, and they got another colonial power, which is today Equatorial Guinea, and nobody cares. And then, of course, you have the Mapuches of Chile. They're 800,000, nearly a million. Huh? They have been not only dispossessed, humiliated, massacred, the Mapuches of Argentina too. Nobody cares. So they have a right to remedial secession, but they're not getting it. That's why I have my, shall we say, doubts about the usefulness of always focusing on self-determination on the basis of remedial secession, because where's the threshold? How much violence, how much violation of human rights must occur so that you go right over the threshold and then you have the right, especially when you realize that even if you go over the threshold and the Tamils have gone way over the threshold, you still don't get it. So that is probably giving yourself hopes that are not backed up by political will. I think that it's far more important to rely on what our colleague, the Honorable Rudra Kamarana, already said at the very beginning. He talked about the League of Nations. He talked about the Åland Islands case. He didn't mention, but indirectly, United Nations Charter Article 39. That is the determination that a situation constitutes a threat or a breach of international peace and security. That is the crucial issue that has to be argued. And it must be clear to everybody that the unjust denial of self-determination, that constitutes a threat to international peace and security. And we have that unjust denial of self-determination in the case of Kashmir, in the case of the Biafrans, in the case of the Bubis, in the case of the Palestinians, in the case of the Kurds. As you probably know, the Kurds held a self-determination referendum in 2017, which was overwhelmingly for self-determination, for secession from Iraq. Did they get it? No. I mean, it's a disgrace. But this is what I say to my students. International law is not applied uniformly. It is applied a la carte. Today we apply it this way, tomorrow we apply it that way. And there are some principles that then get in the public eye and people start talking about these concepts. One of them being the remedial secession of Kosovo because of the ethnic cleansing, et cetera, through Serbia. Now, here is an avenue for the Tamils if you can get several states to demand in the General Assembly a resolution under Article 96 of the UN Charter to ask an advisory opinion from the International Court of Justice similar to the advisory opinion that the International Court of Justice gave in February 2019 in the Chagos Island case. That was a case that was presented, or rather the question was formulated by Mauritius, because the decolonization of Mauritius by the United Kingdom was highly dysfunctional, was highly improper, contrary to international law. So the questions that were, here's the advisory opinion, questions that were presented was the process of decolonization of Mauritius lawfully completed when Mauritius was granted independence in 1968, following the separation of the Chagos Archipelago? Second question, what are the consequences under international law, including obligations reflected in the above mentioned resolutions, arising from the continued administration by the United Kingdom of Great Britain and Northern Ireland of the Chagos Islands, etc., by a decision of 14-1. So it's almost unanimous. And of course, who was odd man out? My dear Judge, John Donahue, the American. It's the same as the decision back in the advisory opinion 2004 on the wall being built on Palestine territory by Israel. And that again went 14-1. Who was the one? My Judge Thomas Bergenthal, the American. So in any event, you see that America tries to have its own rules-based international order, meaning our order. We give the orders and you follow them. In any event, what did the International Court of Justice say in Chagos Island? The court holds that the decolonization of Mauritius was not conducted in a manner consistent with the right of peoples to self-determination it follows that the United Kingdom's continued administration of the Chagos Islands constitutes a wrongful act entailing the international responsibility of that state. It is an unlawful act of continuing character which arose as a result of the separation of the Chagos Archipelago from Mauritius. And they conclude, the court concludes that the United Kingdom has an obligation to bring to an end its administration of the Chagos Archipelago as rapidly as possible, and that all member states must cooperate with the United Nations to complete the decolonization of Mauritius. I think the decolonization of Sri Lanka was improper. I think the United Nations should have insisted on a self-determination referendum. And the two major peoples living in the island of Sri Lanka, the Tamils and the Sinhalese, could have separated in a friendly manner. It could have been done to promote international peace and security, but the opportunity was lost. That doesn't mean they cannot be done again now. I mean, I think, and I have said so in my book published last September, Building a Just World Order, Clarity Press, September 2021. There, I formulated 25 principles of international order. And in those 25 principles, I put number one, of course, peace. Pax optima rerum. I mean, that is the main reason, the raison d'etre of the United Nations. That's why we're there for. But principle number 10 is the right of self-determination as a conflict prevention strategy. I mean, what is the most noble goal of the United Nations is to guarantee world peace. And you guarantee world peace by having an early warning system, like already in one of the earlier webinars that were held, and the Honorable Rudra Kumaran spoke in that one too, proposing a transitional government of Tamil Eelam and an international court on self-determination. I mean, we could have an international court on self-determination. I have proposed in my book that a special rapporteur of the Human Rights Council be appointed just on the issue of self-determination, because it comes up not only in the context of Sri Lanka and the Tamils. There are many aspirants to self-determination, among them the Rapa Nuis, the West Papuans, the Aceh Sumatrans, so many indigenous peoples who have not had self-determination, who have not had the opportunity to participate in the conduct of public affairs in their respective countries. Of course, the genocide that was committed against the Tamils makes the claim of the Tamils to secession much stronger, much more persuasive. But there again, being realistic, you're not going to get it unless you have a couple of major powers supporting your right of self-determination. And unless you have the media. Unfortunately, there is what I call the corporate media, the conglomerates, and there's very little plurality in the media these days. So there are what I call the narrative managers who filter all the news, and if they don't find the issue of the Tamils interesting, well, the people are not going to find out about it. It's only going to be for webinars and for experts who at some point or other are exposed to this. But it is, yeah, it is crucial to win what I call the information war. You must get your case understood. Your case must be studied in colleges and universities. It must be discussed in the New York Times, in the Washington Post, in the Wall Street Journal, in CNN and Fox and CBC and the BBC and the Frankfurt Allgemeine Zeitung and the Neue Zürcher Zeitung. And unfortunately, it's just not considered interesting enough. So my proposals, because I don't want to take all the time available, is to mobilize some sympathetic states in the General Assembly in order to adopt a resolution on the issue of self-determination for the Tamils and elevate the two questions that were asked about the improper decolonization of Mauritius. How about having the same question, the improper decolonization of Sri Lanka, and what is the way forward? How can we ensure that both the Sinhalese and the Tamils have their human rights and their self-determination? That is a noble function for the Secretary General of the United Nations to offer his good offices in order to facilitate a self-determination referendum, to monitor the self-determination referendum, as the United Nations did in Sudan, as the United Nations did in Timor-Leste, as the United Nations did in Ethiopia, Eritrea. But my concern, and it is a concern that goes way beyond the genocide in Sri Lanka, my concern is that the decolonization process in Africa and Asia was so improper that unfortunately there are many aspirants to self-determination who don't have it. And if we don't address their claims in a timely fashion, we are risking that there's going to be violence down the road. So you need a special rapporteur on self-determination. You also need a special advisor to the Secretary General of the United Nations on the issue of self-determination. He is the one, he or she should have the mandate to really understand all of the potential conflicts in the world, to be a whistleblower, if you want, to do early warning so that the United Nations can take prompt and effective action. But going back to this initial question of the importance of the concept of remedial secession, don't rely on it exclusively, because, as I said, it's been denied to many others who also have the claim. I think the stronger claim is a claim based on human dignity. It's a claim based on the very essence of human rights. And that is actually the language used by the drafters of the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, because they're in Article 1, Paragraph 1. It is said very clearly, all peoples have the right of self-determination. Not even the right to self-determination, but the right of self-determination now, not tomorrow, now. So all peoples have the right to self-determination. And then paragraph 3 says that all states, parties to the ICCPR and parties to the ICESC, have an obligation to promote the realization of the right of self-determination. So it's not just that the states shouldn't create problems, should not create obstacles. They actually have to proactively promote it. And that is not what is happening. That is not what we're seeing in the world today. And one last thought, the argument used by Sri Lanka about the sacrosanct principle of territorial integrity. That point was conclusively answered by the International Court of Justice in the advisory opinion on Kosovo, paragraph 80. Read it. It's a pretty long paragraph, but the bottom line is you cannot use the principle of territorial integrity to frustrate the exercise of the right of self-determination. You can't do it. It says it specifically that in all of United Nations action, in all of United Nations resolutions, even in the Helsinki Final Act, whenever the concept of territorial integrity is used, it is exclusively for external application. Meaning, state A cannot invade and annex state B, cannot encroach on the territorial integrity of state B. But state A cannot deny its own population, the people living under its jurisdiction, the right to self-determination. That must be underlined. You must read this paragraph 80 because it has enormous implications in the case of Sri Lanka, as indeed it has in the case of, say, the Catalans. The Catalans also have a claim to self-determination, and that must be recognized. Again, thank you for the opportunity of giving these couple of ideas. I'm available until 10 minutes to 6 our time for any eventual questions. I actually always go to a religious service at 6 p.m. The church is right next to my house almost, so that I will have to leave you 10 minutes to 6. And on this happy note, thank you very much.
Thank you very much, Mr. Alfred Tisayas. நான் ஏற்கனவே கூறியிருந்தது போல இந்த இவர்களுடைய பேச்சிலிருந்து இறுதி நேரத்தில் நம்முடன் இணைந்திருக்கக்கூடிய ராதிகா சித்சவேசன் அவர்கள் இதை சுருக்கமாக கூறுவார். அந்த வகையில் இன்னொரு விடயத்தையும் இங்கு குறிப்பிட விரும்புகின்றேன். கேள்விகள் கேட்க விரும்புவோர், அதாவது இந்த ஈழத்தமிழரின் சுய நிர்ணய உரிமை சாத்தியங்கள் பற்றி கேள்விகள், அதை பற்றிய கேள்விகள் இருந்தால் நீங்க கேள்வி கேட்கலாம். அதனுடையால் பொறுமையாக காத்திருந்து அந்த கேள்வி நேரத்துக்கு காத்திருக்குமாறு தாழ்மையுடன் கேட்டுக்கொண்டு நேரத்தை விரயம் செய்யாமல் சாரதி.
Thank you so much again, Professor Tisayas, for always enlightening us with your knowledge. I for sure have taken so many notes down of all of your speeches that you've given to us and for your discussions. We're for sure going to be looking into all of the articles as well as paragraph 80. And once again, congratulations for your publication of your book. We all look forward to reading it and for seeing you more at these discussions about Tamil self-determination for our rights. And now I would like to move on to our final panelist for the afternoon, which is David Matas. Mr. Matas is an international human rights, immigration, and refugee lawyer based in Winnipeg, Canada. He was a director of the International Defense and Aid Fund for South Africa in Canada in 1990 and 1991, and Canada-South Africa Cooperation from 1991 to 1993. For B'nai Brit Canada, David Matas has been chair of the League for Human Rights from 1983 to 1985, vice president from 1996 to 1998, and senior honorary counsel 1989 to the present. For the Canadian Jewish Congress, he was co-chair of their Race Relations and Law Project from 1985 to 1987, and we are honored to have you here today with us, sir. David Matas, I pass the floor over to you, and thank you once again for joining us.
Thank you. Maybe I should just check to make sure that you can hear me before I.
Yes, we can hear you. Mr.
Yes, okay.
Matas. We can hear you. Thank you.
Fine. Well, what I wanted to do is go over some of the legal precedents and perhaps a little more detail than Prime Minister Rudra Kumaran had done, and talk about the legal background for the right to statehood as a component of the right to self-determination. But before I did that, I thought it might be appropriate in light of Professor Desai's remarks to say a word or two about the value of dealing with the law in this context. Of course, international law is not uniformly respected, but that phenomenon is not unique to the international arena. I mean, we have disrespect of the law, unequal application of the law, even in a national context. But there is a value to the law, even if it is not perfectly realized. As with human rights itself, we are looking with the law for the pursuit of an ideal, the ideal of justice, and it's not really within our capacity at all times to realize the ideal, but that doesn't mean it's not worth pursuing. I take the point that we need media, we need politics, we need NGOs. But one way of doing all that is to stand up for the law. I mean, advocating for the law, pointing out the law, pointing out what the law can and should achieve is itself a form of advocacy that is useful with NGOs, with the media, with governments, because what it does is it's telling all these institutions not just that the law is being violated here, but that the law is important in realizing the values that the NGOs are working for, that the international community is working for. By standing for the law in this area, we are standing for law and justice generally. And so I would not minimize the value of a strong legal position in advocating for the right of statehood as part of the right to self-determination. In terms of the specifics, the precedents that Prime Minister Rudra Kumaran mentioned are worth, I think, revisiting to see exactly what was said there. And I wanted to go through some quotes because they do give a history of jurisprudence in this area, which I think give us an insight about where we can go and what the ground is on which we can stand. So there was this dispute over the Åland Islands, dispute between Sweden and Finland. The Åland Islands were part of Finland. They were Swedish speaking. The Åland Islands wanted to join Sweden. They didn't want independence, but they wanted to become part of Sweden. The League of Nations appointed a couple of commissions, one of which was the second of which was a commission of rapporteurs. And allow me to quote from what the commission of rapporteurs said. They said, but what reasons would there be for allowing a minority to separate itself from the state to which it is united, if this state gives it the guarantees which it is within its rights in demanding? That's the minority, for the preservation of its social, ethnical, or religious character. Such indulgence, apart from meaning the separation being the indulgence, apart from every political consideration, would be supremely unjust to the state prepared to make these concessions. The separation of a minority from the state of which it forms part and its incorporation in another state can only be considered as an altogether exceptional situation, a last resort when the state lacks either the will or the power to enact and apply just and effective guarantees. So in effect, the commission here is saying no in the case of the Åland Islands, but the way it says no indicates a situation where the answer would be yes. What they're saying is that a minority has a right to effective guarantees for the preservation of its social, ethnic, or religious character. If those guarantees are not given, or if given are not effective, then the right of self-determination of the minority becomes a right to separate it from the state of which it forms part. And then we have the precedent of Zaire in Katanga, which Prime Minister Ruto also mentioned. And here we have the African Commission on Human and People's Rights. There was the dealing with a request from the Katanga People's Congress asking for support for the independence of Katanga from Zaire. So the African Commission, again, they said no, but the way they said no, again, gives us an insight into what a yes answer would look like. They said, in the absence of concrete evidence of violations of human rights to the point that the territorial integrity of Zaire should be called to question, and in the absence of evidence that the people of Katanga are denied the right to participate in government, the commission holds the view that Katanga is obliged to exercise a variant of self-determination that is compatible with the sovereignty and territorial integrity of Zaire. So again, we can see from the way they said no what yes might look like. There would have to be concrete evidence of violations of human rights. And there would also have to be evidence that the people are denied the right to participate in the government. And then we have a case in 1996 before the European Court of Human Rights about Cyprus. Again, something that Prime Minister Ruto mentioned, where there was a complaint brought against Turkey by a Greek Cypriot complaining that Turkey was denying her access to her property in northern Turkey. And Turkey at that point indeed had seized control of northern Turkey. And factually, what was happening was correct. But what Turkey's claim was that there was a separate government of northern Turkey, the Turkish Republic of Northern Cyprus. And indeed, the Turkish Cypriot authorities had proclaimed that republic and purported to claim a right to secede from Cyprus. And then Turkey said, well, we're not preventing access to the property, this woman's access to the property. It is this Turkish Republic, a separate state, which is denying access to the property. Therefore, we are not guilty. Again, the answer was no. But also here we have an insight into what yes might look like. There was a separate opinion in that case by Judge Waldhaber and joined in by Judge Reistel, which said, and I quote, "Until recently in international practice, the right to self-determination was in practical terms identical to and indeed restricted to a right to decolonization. In recent years, a consensus has seemed to emerge that peoples may also exercise a right to self-determination if their human rights are consistently and flagrantly violated, or if they are without representation at all, or are massively underrepresented in an undemocratic and discriminatory way. If this description is correct, then the right to self-determination is a tool which may be used to reestablish international standards of human rights and democracy. Where the modern right to self-determination does not strengthen or reestablish the human rights and democracy of all persons and groups involved, as it does not in the instant case, it cannot be invoked to overcome the international community's policy of non-recognition of the Turkish Republic of Northern Cyprus." Now, that statement is interesting in a number of different ways. One is that it puts the issue of the criteria as alternatives, not as cumulative. So in order to turn the right of self-determination into the right of statehood, you don't need both consistent and flagrant violations of human rights and an absence of representation or underrepresentation. You could have either. And that would justify a right to statehood. Secondly, this judgment points out, I think rightly, that the entity which claims a right to self-determination has to respect human rights itself. You can't claim a right to statehood based on a violation of human rights and then turn around and violate human rights. And so that too is a useful comment. We then, of course, and I mean, it's not surprising that Prime Minister Raman and I have the same precedents, because these are the cases that have addressed this issue. And so then there was the situation in Canada, where we had a couple of referenda on secession in 1980 and 1995. The 1980 secession of Quebec from Canada, and the 1980 referendum was defeated handily by 60%. The 1995 was a good deal closer. It was defeated by less than 51%. So it raised the question in Canada, what's to be done in case such a referendum succeeds. And so the government of Canada asked the Supreme Court of Canada a series of questions about that issue. And a couple of the questions dealt with international law. The questions were, does international law give the National Assembly, legislature, or government of Quebec the right to effect the secession of Quebec from Canada unilaterally? In this regard, is there a right to self-determination under international law that would give the National Assembly, legislature, or government of Quebec the right to effect the secession of Quebec from Canada unilaterally? So the court made a couple of statements that are of interest in an international context. One is that when a people is blocked from the meaningful exercise of its right to self-determination internally, it is entitled as a last resort to exercise it by secession. A second was that a state whose government represents the whole of the people or peoples resident within its territory on a basis of equality and without discrimination, and respects the principles of self-determination in its internal arrangements, is entitled to maintain its territorial integrity recognized by other states. Quebec does not meet the threshold of a colonial people or an oppressed people, nor can it be suggested that Quebecers have been denied meaningful access to government to pursue their political, economic, cultural, and social development. So again, we've got these two criteria. One is oppression, and the other is meaningful access to government to pursue economic, cultural, and social development. The last precedent I'll mention, and which we've also heard reference to before, is about Kosovo. And this was actually the International Court of Justice. And this was a yes. The United Nations General Assembly in October 2008 asked the International Court of Justice for an advisory opinion. And the advisory request, the request was this: is the unilateral declaration of independence by the provisional institutions of self-government of Kosovo in accordance with international law? And the court said it was, that it didn't violate international law. This was a 2010 judgment. It's not that long ago. And there's a particularly interesting opinion by Judge Yusuf in this context, where he goes into the issue at quite some length. And this is what he says. Turning now to the issue of self-determination itself, it should be observed at the outset that international law disfavors the fragmentation of existing states and seeks to protect their boundaries from foreign aggression and intervention. It also promotes stability within the borders of states, although in view of its growing emphasis on human rights and the welfare of peoples within state borders, it pays close attention to acts involving atrocities, persecution, discrimination, and crimes against humanity committed inside a state. To this end, it pierces the veil of sovereignty and confers internationally protected rights to peoples, groups, and individuals who may be subjected to such acts, and imposes obligations on their own states as well as other states. The right of self-determination, particularly in its post-colonial conception, is one of these rights. It's worth recalling in this context that the right of self-determination has neither become a legal notion of mere historical interest, nor has it exhausted its role in the international fault law following the end of colonialism. It is a right which is exercisable continuously, particularly within the framework of a relationship between peoples and their own state. In this post-colonial conception, the right of self-determination chiefly operates inside the boundaries of existing states in various forms and guises, particularly as a right of the entire population of the state to determine its own political, economic, and social destiny, and to choose a representative government, and equally as a right of a defined part of the population which has distinctive characteristics on the basis of race or ethnicity to participate in the political life of the state, to be represented in its government, and not to be discriminated against. These rights are to be exercised within the state in which the population or the ethnic group live, and thus constitute internal rights of self-determination. They offer a variety of entitlements to the concerned people within the borders of the state without threatening its sovereignty. In contrast, claims to external self-determination by such ethnically or racially distinct groups pose a challenge to international law as well as to their own state, and most often to the wider community of states. Surely there is no general positive right under international law which entitles all ethnically or racially distinct groups within existing states to claim separate statehood, as opposed to specific rights of external self-determination, which is recognized by international law in favor of people of non-self-governing territories and people under alien subjugation, domination, and exploitation. Thus, a racially or ethnically distinct group within a state, even if it qualifies as a people for the purpose of self-determination, does not have the right to unilateral secession simply because it wishes to create its own separate state, though this might be the wish of the entire group. The availability of such a general right in international law would reduce to naught the territorial sovereignty and integrity of states and would lead to interminable conflicts and chaos in international relations. This does not, however, mean that the international law turns a blind eye to the plight of such groups, particularly in those cases where the state not only denies them the exercise of their internal right to self-determination, but also subjects them to discrimination, persecution, and egregious violations of human rights or humanitarian law. Under such exceptional circumstances, and I could say as by way of aside, it may not be as exceptional as they're suggesting, or he's suggesting. The right of peoples to self-determination may support a claim to separate statehood, provided it meets the conditions prescribed by international law in a specific situation, taking into account the historical context. Such conditions may be gleaned from various instruments, including the declarations on principles of international law concerning friendly relations and cooperation among states in accordance with the Charter of the United Nations, which reflect customary international law. And then he goes on to quote a clause from the declaration, which says, nothing in the foregoing paragraph shall be construed as authorizing and encouraging any action which would dismember, impair totally or in part the territorial integrity or political unity of sovereign and independent states conducting themselves in compliance with the principle of equal rights and self-determination of peoples, and thus possessed of a government representing the whole people belonging to the territory without distinction as to race, creed, or color. This provision, he's going on to say, makes it clear that so long as a sovereign and independent state complies with the principle of equal rights and self-determination of peoples, its territorial integrity and national unity should neither be impaired nor infringed upon. It therefore primarily protects and gives priority to the territorial preservation of states and seeks to avoid their fragmentation or disintegration due to separatist forces. However, the saving clause in its latter part implies that if a state fails to comport itself in accordance with the principle of equal rights and self-determination of peoples, an exceptional situation may arise where the ethnically or racially distinct group denied internal self-determination may claim a right of external self-determination or separation from the state, which could effectively put into question the state's territorial unity and sovereignty. To determine whether a specific situation constitutes an exceptional case which may legitimize a claim to external self-determination, certain criteria have to be considered, such as the existence of discrimination against the people, its persecution due to its racial or ethnic characteristics, and the denial of autonomous political structures and access to government. The decision by the Security Council to intervene could also be an additional criteria for assessing the exceptional circumstances, which might confer legitimacy on demands for external self-determination by people denied the exercise of a right to internal self-determination. And I point out in the case of Kosovo, there was such a finding by the Security Council. Nevertheless, even where such exceptional circumstances exist, it does not necessarily follow that the concerned people has an automatic right to separate statehood. All possible remedies for the realization of internal self-determination must be exhausted before the issue is removed from the domestic jurisdiction of the state, which had hitherto exercised sovereignty over the territory inhabited by the people making the claim. In this context, the role of the international community, in particular of the Security Council and the General Assembly, is of paramount importance. Now, that's a rather long excerpt, but it's worth pointing out because it's a rather, I think, good statement of the present state of the law. And it does produce an additional criterion which the others hadn't before, which is exhaustion of local remedies. Now, I just wanted to point out, I mean, we've heard, of course, about the violations in Sri Lanka, but we've also had tribunals that have come to that conclusion of violations. There was a People's Tribunal in January 2010 in Dublin that crimes against humanity had been committed in Sri Lanka against the Tamil people. There was a second People's Tribunal held in Bremen in Germany in December 2013 that genocide had been committed in Sri Lanka against the Tamil people. We also have the Office of the High Commissioner of Human Rights in the report on accountability that was presented for the Human Rights Council and scheduled to be presented in March. It was released in January, which basically says that local remedies in Sri Lanka have been exhausted in terms of accountability. and invited states to use universal jurisdiction to bring perpetrators in Sri Lanka to justice, and to consider engaging the Security Council to refer the crimes to the International Criminal Court. So what we have, I would say, is already pretty strong, repeated statements of principle about what triggers the right to statehood as part of the right to self-determination, and also determinations by international instances that the facts of Sri Lanka on the ground and the way the Tamil people have been treated bring into play this legal right to statehood as a component of self-determination. So that's what I wanted to say for my remarks. Thank you very much.
Thank you, Mr. Matas, for that amazing and very insightful conversation with us. Really, we really, truly find honor in getting to have people like you, experts, come here and be able to share your knowledge with us. You know, it's very touching that we have your support for the Tamil community, and we do invite you back again to our discussions in the future. Thank you so much.
Nandri, Shardi, Nandri. டேவிட் மேட்டர்ஸ் அவர்கள் நீண்ட பல காலமாக ஈழத்தமிழர் விவகாரத்தில் தொடர்ந்து செய்யப்பட்டு வருகின்ற ஒரு சட்ட வல்லுனர், சர்வதேச மனித உரிமை சட்ட வல்லுனர் மற்றும் அகதிகள் சட்ட வல்லுனர். அந்த வகையில் ஒரு விடயத்தை நான் இங்கு குறிப்பிட விரும்புகின்றேன். 2012 காலங்களில் நாடு கடந்த தமிழீழ அரசின் பிரதமர் மதிப்புக்குரிய உருத்திரகுமாரன் விஸ்வநாதன் அவர்களுடன் தொடர்ந்து இணைந்து வேலை செய்து கொண்டு வர ஒரு நபராக டேவிட் மேட்டர்ஸ் அவர்களை நாம் அறிந்து வைத்திருக்கின்றோம். ஒரு விடயம் மட்டும் இங்கே நான் குறிப்பிட்டு விட்டு சாரதி விட்டேன், டைரக்டா இந்த கேள்வி பதில் இதுக்கு போலாம். ஒரு விடயம், இந்த சட்ட வல்லுநர்கள் கூறின கருத்துக்களின்படி ஒரு விடயம் நாம் எல்லோரும் புரிந்து கொண்டிருக்கின்றோம். என்னென்று சொன்னால், இது ஒன்றும் புதுசில்லை. அதாவது ஈழத்தமிழர்கள் தமது சுய நிர்ணய உரிமை கூறுற விடயம் புதுசில்லை. ஆனால் எமது மக்களுடைய ஆதரவு இந்த ஈழத்தமிழர்களின் சுய நிர்ணய உரிமைக்கான போராட்டத்துக்கு முழு ஆதரவையும் எந்த அமைப்புகள் அல்லது செயற்பாட்டாளர்கள் இந்த விடயத்தை முன்னெடுக்கிறார்களோ அவர்களுக்கு நீங்கள் உங்களை முழு ஆதரவையும் கொடுக்க வேண்டும் என்று இங்கே நான் தாழ்மையாக கேட்டுக்கொண்டு, இப்பொழுது இந்த கேள்வி பதில் நேரம். தயவு செய்து உங்களுடைய கேள்விகள் யாரிடம் கேட்கிறீர்கள் மற்றும் இந்த ஈழத்தமிழர்களின் சுய நிர்ணய உரிமை சம்பந்தமான கேள்விகளை மட்டும் இங்கு முன் வைக்கும்படி தாழ்மையாக கேட்டுக்கொண்டு, அந்த வகையில் நீங்கள் கேள்விகள் கேட்க விரும்பினால் உங்களுடைய கையெழுத்தும் அடையாளத்தை அழுத்தினீர்களானால் நீங்கள் கையை உயர்த்துற அந்த வரிசையில் உங்களுடைய கேள்விகளுக்கு கேள்வி கேட்பதற்கான வாய்ப்பினை கொடுக்க முடியும் என்று இங்கு கூறிக்கொள்கின்றேன். அந்த வகையில் இப்பொழுது நாங்கள் நேரடியாகவே கேள்விக்கு செல்லலாம்.
Sorry for the interruption. Dr. Paramalingam Anna also in the meeting. Can you give him 3 minutes or 2 minutes, please?
Definitely.
Thank you.
Param. Can you unmute him? மன்னிக்க வேண்டும், இங்கு இணைந்திருப்பவர்களே. நம்மோடு டாக்டர் பரமலிங்கம் அவர்கள் பிரித்தானியாவிலிருந்து இணைந்திருக்கின்றார். அந்த டாக்டர் பரமலிங்கம் என்பவர் சர்வதேச சட்டம் போன்ற அவர் தானாக வழங்கப்படுத்துவார். ஒரு புத்தகம் ஒன்று எழுதியிருந்தார். அவரும் ஒரு சட்டத்தரணி. சர்வதேச மனித உரிமை விவகாரங்களில் பல நிகழ்வுகளில் அல்லது பல சந்தர்ப்பங்களில் இணைந்து வேலை செய்த ஒருவர். அந்த வகையில் மதிப்புக்குரிய பரமலிங்கம் அவர்களை ஒரு நிமிடம் பேசுமாறு கேட்டுக்கொள்கிறேன். Mr. Paramalingam, yeah, you want to say that in English?
Yes. Thank you very much. Dear friends who listening to the discussion today. Actually, I don't want to take much of your time because already the highly qualified experts have given appropriate explanation and thorough analysis about the right to self-determination and the law applicable to the Tamil people of Sri Lanka and the difficulties in implementing the right to self-determination as far as Tamil people are concerned. I am particularly impressed by Professor Alfred D. Zoysa, who has made comments on the improper decolonization and the issues around that. At the moment, I am working on a treatise or book on decolonization in international law, improper decolonization and focus on internal conflict, which is very relevant and appropriate to the Tamil people of Sri Lanka. He has mentioned various things about how we can go about it to implement or to enforce the right to self-determination. And also he has suggested we have to start the work in order to proceed or implement the right to self-determination. My understanding or my observation in this field is actually there are already United Nations, particularly the General Assembly, they are in the process of passing resolution. Every year, they continue to pass right to self-determination and realization of the states. It is going on for the last 20 years. Whenever I read this every year, without fail, I used to observe the resolutions, particularly this right to self-determination resolution, and a bit frustrated. For the last 3 years, I used to write by October or November to the Secretary General Legal Council of the General Assembly to indicate them, pleading them to create or adapt and draft and adapt appropriate, meaningful resolution on self-determination and focus on internal conflict. As you all know, they don't want to respond to individuals or any organization other than the member states. In fact, it is important if Professor Alfred is already listening, particularly otherwise, Dr. Livingstone, please make a note because you will be going to Sri Lanka. It is appropriate to discuss this matter with them and the diplomatic community in Colombo. Actually, in the resolution, on behalf of the Tamil people, I have made a proposal for the General Assembly Legal Council to consider to adopt some meaningful mechanism in order to implement, in order to take up the right to self-determination to the International Court of Justice. I devised a similar mechanism requesting them, at least members of the northern eastern provinces, at least 15 people can sign and refer the matter to the International Court of Justice. This particular right should be considered and the issue should be internal conflict and the difficulties in implementing the right to self-determination has to be considered. Unless the states cooperate, unless the General Assembly is drafting an appropriate, meaningful resolution in order to facilitate the jurisdiction to the International Court of Justice, it cannot be meaningful. Therefore, we all have to work out with the support of the experts on international law, how we can create a mechanism through the General Assembly to eliminate the suffering of the people caused by improper decolonization. I am very particularly addressing on the improper decolonization only. As far as Tamil people of Sri Lanka is concerned, I wish to draw the attention of Dr. Livingstone. As far as Tamil people are concerned, we are victims of 3 colonial rulers. Portuguese came there, they didn't leave immediately, they were there for 150 years. Dutch came, they continued to stay there for nearly 150 years. Fortunately, Portuguese and Dutch did not dismantle our territorial integrity they maintained, although they have conquered us, they did not remove our territorial integrity or international boundaries. Unfortunately, in Trincomalee, there was a war between French and British. Unfortunately, British won. That is the reason why we are suffering today. As far as British is concerned, they wanted to keep the island of Ceylon under their control in order to maintain and control Indian subcontinent. As a result of it, they adopted the divide and rule policy in Sri Lanka, in Ceylon, in order to continue to keep Ceylon under their control, particularly to control Trincomalee Harbour, for controlling in India for the period they would like to stay there. If French have won the war, Tamil area would have been a French colony. At the time of the decolonization, we would have been a separate country. That is the reason I mentioned. As far as British concerned, when they came to Sri Lanka, in fact, when they came to Sri Lanka, also, then Ceylon, there were two monarchies were there. One is Kandy Kingdom, other one was Vanni Kingdom. British are the people conquered these two kingdoms. They should have realized the appropriate customary international law or intertemporal law, how to deal with the original kingdoms. They did not observe their legal obligation. They amalgamated, they conquered, and after a few years, they amalgamated the entire Ceylon. That is the fundamental cause of the suffering today. I wish to, again, I wish to point out, in 1946, when they passed a bill in order to decolonize Ceylon, in the bill introduced a constitution of unitary form of government. But one of the conservative MPs at the time pointed out, island of Ceylon was not a single political unit. There are two races in Ceylon. There are two language-speaking belts in Sri Lanka, in Ceylon. Therefore, unitary form of government is going to fail the democracy. Minority, the people of the northern eastern provinces continue to going to be minority, and it is going to fail the democracy in Sri Lanka. That is a perfect political prediction, and we are experiencing now. Therefore, dismantling the improper decolonization, political setup created by improper decolonization in accordance with the regimes applicable to Sri Lanka, United Nations, all the regulations and the resolution applicable to the internal conflict has to be implemented at Sri Lanka. The Security Council in the Kosovo affair, they have adopted a resolution in order to enforce the interim administration under the supervision of UN. After 2009 war, the Security Council should have treated the Kosovo resolution as a precedent, and they should have, in fact, they should have implemented that particular administration in Sri Lanka. It is unfortunate because the arms producing countries, what they do is when they sell arms to the states affected by internal conflict, they say, you can buy the arms from us, we will take care of your any punishment by the Security Council, we will take care of you. Because they have the veto power, that is the reason what Tamil affairs or the suffering of the Tamil people were unable to be discussed in the Security Council because veto power, arms sale package are linked. It is unfortunate. So this sort of problem has to be resolved in order to implement the right to self-determination. Thank you.
Thank you very much. Before you go, Mr. Paramalingam, can you introduce yourself? I basically didn't introduce you properly, and your profession and what you're doing. Can you do that for me? Thank you.
Yes, actually, I am a lawyer by profession. I am an academic in international law. I have, for my doctorate, I have submitted a dissertation on sovereignty international law, the legal dimension of the Tamil people of Sri Lanka and international law. It was supervised by Professor Patrick Thornberry at Keele University, and it has been published as a book now. And also it has been published as in Tamil with a translation that is Ilangayil Tamilararamai, very much identifying the current international law and the entitlement of Tamil people as a nation, and how we are entitled to seek remedy through the United Nations.
Thank you very much, Mr. Paramalingam. Thank you very much. With that, we're going to go into some questions. We'll allow around 10 questions. Quickly do that, and then we will go to Bosco Meridas from France, and then we will go to Radhika Sitsapaisen for the remarks, closing remarks. So with that, there are 2 people have raised their hand. I'm going to call on the order that they have raised their hand. Saying that, Mr. Manivannan, you can unmute yourself and ask your question. Like I said, please direct your question based on Eelam Tamil's right to self-determination. Thank you.
I want to ask a question to Zayas, because he said that the impediment to the self-determination by a state warrant the people like Tamils the right to self-determination, external self-determination. Because in 1976, we had our resolution of Vattakotte resolution called for the independence. And this was again established by 1977. General election has been used as a referendum for
Alfred Desire has
okay. I will ask a question to David Massas or Livingstone.
Make sure your questions are short, please.
This resolution, and then that is the mandate by the Tamil people in 1977. Again, that Sri Lanka has continuously, after that mandate, the Sri Lanka has continuously denied the right of self-determination for Tamils by introducing the 6th Amendment to the Constitution, and then it brought in, it is against the international law, and that is still remains in the statute book until now. And Tamils are not allowed to say their aspirations. And this is a great violence, and then plus with the genocide, whatever happening from 1948 onwards, Tamils, what is the remedy for Tamils? Because they have already exercised their self-determination right, and they have confirmed it in 1977 election, and that has been denied from 1977 election forward. And what is the remedy for Tamils at this stage? Because has it been taken into the consideration of the international community that the Tamils have done this?
Thank you, Mr. Manivannan. Mr. David Maras, would you like to answer these questions?
Sure. Well, I would say just generally, I mean, it's not just true internationally, but it's even true in local justice system. The wheels of justice grind slowly, but they grind inexorably. And you can see this with the Human Rights Council, the way it's dealing with Sri Lanka. Session after session, they say investigate, provide accountability, and Sri Lanka does nothing. But it doesn't stop. They keep on coming back. They keep on asking for more. They do other things. And now they've got to the point where they're saying, invoke universal jurisdiction, go to the Security Council for referral to the International Criminal Court. And there are international instances that can deal with this matter. There is the Genocide Convention. Sri Lanka is a party to it. And any other state, and there's lots of them, can bring Sri Lanka to the International Court of Justice in violation of the Genocide Convention. Gambia has done that in relation to Myanmar, and Gambia has no particular connection with Myanmar. They just did it because they felt that there was a violation of the convention, which there may well have been. And so that could easily happen with any one of the signatory states. And there were more than 40 signers, co-supporters of the resolution in the Human Rights Council about Sri Lanka. So and they're all signatories to Genocide Convention. So there's a wide swath of states that can do that. There could be a resolution of the General Assembly referring also to the International Court of Justice, as happened with Sri Lanka, as happened with Kosovo. There could be, using Article 15 of the Statute of the International Criminal Court, a request to the prosecutor to start a preliminary examination against Sri Lanka based on, even though Sri Lanka is not a party to the court statute, based on the coercive environment that has generated deportation, which is a crime against humanity in the court statute. And the NGO Tamil Rights Group has already done that, and other NGOs could do that, and states parties to the court statute can do that. And of course, the Security Council can refer the matter to the International Criminal Court, which would obviate the need for a preliminary examination and go beyond the crime against humanity of deportation. So that, I mean, there are legal remedies available. It's just a matter of having the time and patience and endurance to get them going. That would be my answer.
Thank you. Next, Dharmarajan from Canada. Dharmarajan.
Good morning or good evening for everyone. I'm very impressed by our international experts, how they are presenting the issue. It's crystal clear. We all crystal clear. We understand our struggle is a truth one. So I would like to ask Dantas, Doctor, as a, I am in all states, something like that, but I believe with my younger generation to lead our, truth. So it's not going to be end in 1 or 2 years. I understand it's a long struggle. As a new, we don't have any country support for us, our truth cause. So for the younger generation perspective, what kind of information we can pass through as elders? That's my first question. The other question, I don't know, anyone can answer for this. There's a 2009 Muliwaikal event. It's evidence for everyone in the world, in this, what you call IT world. Why we cannot, why that evidence is there, why we cannot achieve? Please answer all these questions. I have been, working with the other many parties. Thank you.
Mr. Dharmarajan, your question was directed to Dr. Livingstone. Is that correct?
Yeah, Livingstone. Yeah.
Dr. Livingstone, are you still there? Bosco, is Livingstone still?
Or else anyone can, it's a gentle.
In that case, maybe we can ask Pradhamar Uruthrakumaran to answer this question. Is it okay?
Please.
Yes, he's here. Yeah.
Is it directed to me or?
No, it was directed to Mr. Livingstone, but I guess Livingstone has some network issue. And if you want, I can ask him to repeat the question if you.
Okay, Mr. Uruthrakumaran, very glad to meet you here. I just want to know, our generation, they are having so many troubles. They have to, live with their day-to-day living. So they struggle a lot. It's very difficult for them to carry
very short, please, because there are a lot of people on the line.
Okay. Okay. How we can educate our younger generation I'm strongly believe in younger generation at this time. They can speak very clearly, so not complex. How we can, improve that younger generation communication. I think it's all done. It's doing all these younger generation are doing good job. Like here Brampton, there's a museum. It's taking place. So
Thank
could you
you.
elaborate
Yeah.
on
Thank
that,
you.
please? Thank
Mr.
you.
Rutukumaran, answer this question.
Just briefly, by participating events like this, and then we can bring the youngsters also into the fold, and then they can also take the course. The other thing what I've been thinking is to arrange some seminars in those universities. Those universities, most of the universities, there will be South Asian Association or International Association. So maybe we can sponsor some discussions or some seminars on these topics in those universities. Through that, I think we can mobilize the younger generation, and they are tech savvy. They are better than us on those things. So probably we need their help very much. So I would suggest that we'll have these kind of events in their universities. Thank you.
Thank you very much. Mr. Roy, you want to unmute and ask your question? Please direct your question to whom.
Thank you, Vimal. This question is directed to David Matas. I'm Roy Vignaraja, a member of the transnational government working with PM Rudrakumaran. My question, well, I've been listening to all these international experts that were presenting today, and also Prime Minister Rudrakumaran. Of course, Prime Minister pointed out some good facts and conditions for a remedial cessation. Then Professor Desire spoke about improper decolonization, and finally, David, you spoke about the ruling given in 2000.
Your question to be directed to whom, Mr. Roy?
It's to David Matas.
Okay, go ahead. Thank you.
From all these three presentations, what I gathered was that the crux of all these presentations boils down to one thing, which is media, mobilization of governments, and the application of these various challenges, application of various international legal points or points from international law or the covenants, plus facing the challenges that are contrary to the self-determination of the Tamils. So having said that, David, can you tell us how we could incorporate all these things together and formulate a mechanism to approach the General Assembly, requesting for a special rapporteur, the Security Council, and the various other organizations or various other entities that make a final determination on our case?
Thank you, Mr. Roy. Mr. David Matas.
Well, if you're asking me how you get a resolution passed in the General Assembly, I think it would be useful to work in a coordinated fashion. Within the Tamil community, but also within the like-minded community, because the Tamil diaspora is in a lot of different countries now, and they should be approaching the governments of those countries to work together to bring this matter to the General Assembly. There is a precedent with Kosovo, admittedly in a context where there was an existing state, but or an existing authority, but the Sri Lankan community is the Sri Lankan state is not, I would say, particularly popular within the global international community. It's not been able to muster a defeat of the Sri Lankan resolutions in the Human Rights Council, and my just because I mean, the Human Rights Council, to a certain extent, although it's a much smaller number than the General Assembly, is a good indicator of what could pass as a General Assembly. And my guess is if these resolutions are passed consistently against Sri Lanka in the Human Rights Council, they could also pass in the General Assembly. And it's just simply a matter of mobilizing the like-minded states to move on from the Human Rights Council to the General Assembly. And so I would encourage the Tamil diaspora to approach the governments of the countries in which they are now located to do exactly that. That would be my suggestion.
Thank you very much. With that, next, Nisha from Global Tamil Movement, France. Nisha.
Hello, good evening, everyone. I'm Nisha from France, from Global Tamil Movement. My question was originally addressed to Dr. Livingstone Siwenyana. I don't know whether he is here.
Unfortunately, he is not here.
Okay, so maybe someone else can answer to my question. I wanted to know if there is any chance for the people working within the framework of the United Nations to organize a hearing inside the 3rd and 4th committee regarding the Tamil issues, because talking is very good and to make people awareness is very good, but at the same time we have to work inside within the framework of the UN. So now we are speaking about the self-determination, but there is a place where this should be deeply and thoroughly discussed, and that is the 3rd and 4th committee. And I would like to know if anyone can of the speakers can answer to my question, or maybe Bosco, as he is a specialist on this issue, or maybe someone else can answer to that. And I also wanted to ask to Dr. Livingstone if he intends to send any reports on self-determination issues to the General Assembly after this session, which is upcoming. Thank you.
So you had two questions. Who want to answer? Mr. Ruthukumaran, Prime Minister Ruthukumaran, you want to answer this question, or we can pass it to him?
The question is, whether we can bring our issue to the 3rd committee. I'm not quite sure, because the 3rd committee deals with decolonization. But today, I think Dr. Alfred touched that issue, and Mr. Paramalingam also talked about that. But to be honest, I must say I'm not quite sure whether we can bring our issue within the purview of decolonization at the moment, because if we go along, because if that comes true, then I think that the whole map of Asia and Africa have to be redrawn. And I don't think in my view, I'm not quite sure the international community is willing to redraw the whole map of Asia and Africa. But then the recent opinion that came on the Chaplock case, I think a couple of years ago by the ICJ, I must say I haven't read the whole opinion. So give a short answer, in my view, it's a difficult proposition to bring our issue within the purview of the 3rd committee. Maybe Paramalingam can say something, I think, because this is his speciality. Maybe he can also say something about it. Yeah.
Yeah, Paramana, can you answer this question?
Yes. Yes. Actually, Rutra, my understanding is the person who asked the question, she spoke about the 4th committee.
Yes.
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 Okay. The 4th committee is actually if the countries which are not decolonized and issues relevant to non-self-governing territories, we can, if they are entitled, if they allow us to discuss as a Tamil question at the 4th committee, it may be a good idea. We can articulate, we can advocate presenting our case by why it is improper decolonization. So therefore, whether they will consider the Tamil issue. As Mr. Ruthukumaran said, my understanding is that we will not have local standee at the 4th committee. Therefore, we have to take up the matter 24th committee, where they consider the serious and systematic political violations. So Sri Lanka has been decolonized, whether properly or improperly, and Sri Lanka is a member of the United Nations. Therefore, when there is a serious and systematic violation of rights are taking place, the matter has to be discussed with the 24th committee. for that purpose also, the members have to, members of the 24th committee have to facilitate us in order to present our case.
Thank you.
That is my understanding.
Yeah, thank you. In that case, I just want some input from Bosco Meridas from France, Global Tamil Movement. Bosco, can you give some of your input on this matter?
Yeah, good evening, everyone. So just for remember that, you know, the fourth committee, it's on a special committee on decolonization, and third committee, we can talk about right to self-determination. So for example, the current for this year, the president of the third committee is His Excellency Mohamed Siad Douale from Djibouti. And he's very, very interested because just for last week, he had a meeting with the civil society, and he's very interested to have a special meeting regarding the right to self-determination. So that's why I think the question was initially for the UN Special Rapporteur, because, you know, we need to have also the support of the Special Rapporteur, because they were supposed to also to make report for the third committee. So that's why, I mean, even I asked to everyone who are there, if they can send their plate to the third committee president. He can also have a hearing with a civil society regarding that. So I send you on the text message about the contact of the secretary of the committee, so you can send to them, and it might be addressed to His Excellency Mohamed Siad Douale. So yeah, that's why it's very, I mean, the fact it's from the Tamil civil society, if we can send our plight to them, and the president will decide if he can arrange or not. So first we need to send our plight. Thank you.
Thank you. That was Mr. Bosco Meridas. The reason I called him is he has been doing some researches on decolonization and self-determination for a long time. I have learned a lot of things from him in regards to that matter. Now, Mr. Kulandaswamy has raised his hand. I think this is Father Kulandaswamy. You can unmute and talk. Your question, please.
Thank you, Vimal.
Thank you.
Thank you very much for your. This is a question to the David Matas. I just want to make that the market economy reigns the entire world. In such a situation, how is possible that self-determination is possible for Sri Lanka, because most of the countries mainly go after a market economy. So they break the barriers or boundaries, even they violate all the laws possible, and no justice is being practiced in their country. Such countries come together and have a human rights council, and how they look at self-determination in Sri Lanka. Thank you.
And this question directed to? If anybody wants to.
David Matas.
David Maras?
Yes.
Mr. David Maras?
Yes, well, I mean, this raises the whole question of it's a question referred to the market economy. And when you're looking at the market economy, what you want to look at is multinational businesses and supply chains and the extent to which they are contributing to human rights violations or combating human rights violations. I mean, a complete boycott on everything from Sri Lanka is too broad, but doing nothing is too narrow. There are human rights standards that apply to transnational businesses that are set up through the Organization for Economic Cooperation and Development, and there are national focal points in every country that's a member of the OECD to basically enforce the principles, and it's part of the UN human rights system as well, the business and human rights. And so I must confess, is an area in terms of Sri Lanka where I'm not really that familiar about the extent to which multinational businesses are complicit in the human rights violations against the Tamils, but it's an area of research worth investigating or advancing, and then targeting the companies that are complicit in some way or another, either directly through their operations or through their supply chains or through their customers, and drawing to their attention the international human rights standards that relate to multinational enterprises, ask them to comply with them, and if not, invoke the compliance mechanisms. That would be my answer.
Thank you very much. With that, the final two questions, and then we're going to go move forward. The first, next question will be from our own moderator, Shardi Ramesh. Your question, please.
Hi. Yeah, so I'm the moderator, but I did have my own question. It's more so directed towards all of the speakers, but I will call upon Mr. Rudrakumaran to answer my question if he may. As a young adult, as someone who's part of this generation, also coined as Gen Z, how would you say that we can go about bringing on our own social change and bringing on awareness about these special repertoires and about, political considerations that we can take on? Because coming from a perspective of someone who is in their undergraduate, we don't really hear much about, Article 1. We don't hear about these different resolutions as much as others in professional fields may hear. So how are we to, per se, educate ourselves about it? And then I would say a second question that would follow up on that would be, for those that utilize social media platforms, how do we ensure that these things that we bring to light do not get buried? Because I know that in the past, a lot of the Eelam Tamil songs and written pieces regarding Eelam Tamils and the Tamil genocide have often been taken off of social media. They've been banned off of YouTube, off of Spotify and Apple Music. This was a whole thing that was happening last year and continues on into this year. How do we overcome this obstacle of basically trying to express ourselves and trying to raise awareness when it seems that we're constantly being brought down in this social and political consideration?
Thank you, Mr. Rudrakumaran.
Let me handle the second question about the social media, because we know, we are all aware that they take our flags and everything from the social media. And initially we thought of we explored the possibility of bringing legal action in the US against Facebook. Then we consulted some lawyers also, but then it turned out to be that, the fact is that it's a private platform. Facebook is not a public platform, it's a private platform. So therefore they have every right to do whatever they want. So the First Amendment, the US Constitution First Amendment is not applicable. In fact, they removed President Trump also from their platform. So it's very deep. I don't think we have any option to bring any legal action against them. But I understand that the Facebook also, they have a body where we can make some complaints, and that body will review our complaints and then they'll make some decision. So I think that is the route we have to take regarding the social media. As I said, I don't think we have legal recourse. The First Amendment is not applicable. Regarding the second thing, as I said, the first question about how we can bring the younger generation into the fold, there are two things. One is, as I said, we'll have these kind of discussions in your universities. And Transnational Government of Tamil Eelam, we have a massive action. We establish something called Massive Action Plan and 15 program. The two programs are tomorrow's leaders. We invite people and ambassadors, young ambassadors. So we have these plans, but unfortunately we haven't executed these plans. Our plans is to bring youngsters and they have some kind of a course for 3 months crash course or something, like bring experts and have a weekend classes and then promote them to take this message to various countries. Anyway, after hearing this, I will try to execute those plans. So those are the plans we thought about. We have a advisory committee expert panel. So we thought how we can bring the youngsters. And these are the two plans we identified, tomorrow's leaders and the young ambassadors. I'll try to do whatever way we can bring you guys into this this mission. Thank you.
Thank you very much. Thank you very much. Do you have a follow-up question, Sardi?
Oh, no follow-up. Thank you
Thank
for
you so much. With that, the final question is going to be from Mr. Dagmar Hellman. Dagmar Hellman. Sorry if I have pronounced your name incorrectly.
That is my wife's name.
Okay.
My name is Rajanayagam. I have met Rudra Kumar. He knows me, I think so, long ago in Australia. And so my question is, I think I've taken the question. I'm not an academic person, I'm an engineer. So with the present situation in Sri Lanka, the issue of self-determination has been pushed back by the IC, the back burner, as they are fully engaged in the Ukraine fiasco. Since India is a regional power, the West as a bloc has left the matter to India, but India fully engaged with Pakistan, China, and Kashmir. For the self-interest of the West, it stands behind India, and maybe for the self-interest of the West, it stands behind India, maybe due to economic reasons. China and Russia are playing their own game to serve their own interests. In such a complex situation, what should the Tamils in Sri Lanka do to serve their own interests? And it can't be true. It can't be true. And the credibility of the West is to be questioned. So here I want to know, 30 years has gone and nothing has happened. Food was served and taken away in 2004. So my question is it something that is there a solution or light in the tunnel for us? Because looking pragmatically, leaving all the academic work, all the books, what we can take, which platform we can sit, or an exit platform that we can take our case forward. So from my point of view, is India the starting point? And this question I'm going to give it to Rudra Kumar, because PGT is a registered political organization compared to there's no others in the world. Okay, so.
Mr. Rudra Kumaran.
Yeah, thank you. Yeah, as I mentioned in my presentation, that as Professor Jeffrey Robertson said, that for an independent struggle to be won, there are 4 conditions should be met, and the first condition was identified that our interest and the interest of some of the, at least 1 or 2 of the big powers should align. But I think there's a potential, there's a possibility for that to happen, because recently we issued a statement also. We said that that to maintain Tamils as a viable, distinct entity in the island of Sri Lanka is necessary, not only for the humanity, but also for the India's own interest. So that's why here, especially given the fact that the growing Chinese footprints in Sri Lanka, I think the India's national security interest and our political interest can align, can meet at one point. I think that's the way I think we can take this issue. The other thing I also would like to say one of the things, that we don't want to put a lot of things in the basket, in the UN basket. UN is a club of states, and they all try to protect their own interests. So we have to create some forums outside UN, and where we can promote our interest. That's the thing. We want to focus on that one also, rather than simply focusing on the UN, because I am very skeptical about the UN, whether the UN can deliver anything. But we have to use UN also as a forum. But anyway, just to come to that your question, that's where we look at it. We see that our interest, our political interest, and the interest of other democratic countries, because our TGT's foreign policy is principled realism. We believe in realism, but at the same time, we are not going to just close our eyes to whatever happens. So our foreign policy, we call it as principled realism. And we believe, because we share the common democratic values, with India, with the US, we share common democratic values. So based on that, I think we can, our interest and the democratic, powerful democratic countries' interest can meet at one point. Thank you.
Thank you, Prime Minister Rathakumaran. At that same note, I also wanted to hear from Mr. Bosco Merida that he has been working at the UN Human Rights Council for a long period of time. And Mr. Bosco, can you give your input for a minute, please?
I think we need to understand that the problem is, on the right to self-determination, only on Tamil perspective, we always put it as a geopolitical issue. The fact is, you have the fourth committee. You can see there are 29 full member, and among 29, only 3 or 4 countries are difficult to convince. First, so all the process for the right to self-determination of the country, a nation, it's start from the fourth committee. So, for example, Barbados have the possibility. Last year, it was Barbados who was the presidency of that committee. So, just for we need to stop to talk about geopolitics, because of course we need to have the support of India, but India will support once we have the support from the fourth committee members. For example, even Indira Gandhi, she has told to Nedumaranaya about year 83, something like that, that she mentioned to the Tamil people to go and talk in New York at the fourth committee. I mean, at that time it was the committee of 24. So it's very important to work within the UN framework, and we can make the change. For that, Global Tamil Movement Network, we have all the access necessary. And I mean, for example, last week there was the meeting with the third committee president, and he's very supportive. I mean, he's very interested to work on the right to self-determination. He's okay. For example, he said okay for Western Sahara people to bring the issue and to have a hearing at the third committee. So, I mean, this is how we can process. So, I think for me, we talk too much. The problem is Sri Lanka is winning on the foreign policy, because they respect all the country and they work even small countries, they are working strongly. And Tamil people, we need to first use the fourth committee. And also, as I said, I mean, the fourth committee, it's really specialist for the creation of the new countries. Until now, from 60s, there was about 84 countries who get their freedom with the fourth committee. And if we talk about the third committee, it's the possibility to have some report and hearing, and with that also we can look forward. So even for example, a country like Venezuela, they said they are not ready to support any resolution, any country resolution in Geneva, but they are ready to support us for our right to self-determination with the fourth committee. So that's why I think we need to take the right track and move forward. So, and also people who are interested, I mean, from New York, if they want to have access or understand the process and working with the United Nations mechanism for the Tamil rights to self-determination, we can give them all the access for the General Assembly. So please join us, and thank you.
Thank you. That was the final question. Let us, Shardi, let us move on. I guess I'm going to give it to you, and then you can move forward with your agenda. Thank you very much for everybody who asked questions and who answered the question. Thank you. Shardi?
All right, perfect. So that concludes our discussion portion for this afternoon's event. I would like to now pass the floor over to Ratika Sitsibaisen so that she can deliver our summary and conclusion. Just a little bit about Ratika because she is amazing. Not only was she the first Tamil to be elected to the Canadian federal parliament, but she was also the first woman and first visible minority to be elected as a member of parliament for Scarborough Rouge River. She was also the youngest member of parliament in the Greater Toronto area, so we are lucky to have her here. Thank you so much for joining us, and I pass the floor over to you.
Thank you, Sharathi. Elorukum vanakkam. Good morning, afternoon, evening, everybody. I'm joining you from Orangeville, which is the traditional territory of the Anishinaabe, the Haudenosaunee, the Ojibwe and Chippewa peoples, and the Potawatomi and Odawa of the Three Fires Confederacy. And this territory is covered by the Upper Canada Treaties and the Haldimand Treaty. Thank you to all of our speakers and the great questions that our participants had put forward today. I have 9 pages of notes in very small font, so there's no way that I'm going to do anybody proper justice with a true summary of your arguments, but I'll do my best to make a very short overall synopsis of what we spoke of today. And today's discussion was about Eelam Tamil's right to self-determination, and is remedial secession the best way forward? Remedial secession being a process whereby a people can declare independence. It's a very big and confusing world of international law that we operate in. So we heard from Dr. Livingstone Siwenyana about what is self-determination and the fact that it is a right of peoples who are being oppressed, and that they have a right to actually be able to speak out and take the measures that are necessary to be able to exercise that right of self-determination that international law allows for peoples if they are being violated and oppressed by a state for a very long time. And for a very long time, the UN and the international community has been very well aware that the Sri Lankan state has been the oppressor of the Tamils, that nation. We heard from the Prime Minister of the transnational government of Tamil Eelam, Mr. Rudrakumaran Viswanathan, as well, about his comments, where he really focused on the right of self-determination as the mother of all rights, if I may quote you, and spoke of who can exercise these rights. And he focused again on the people who can exercise that right of self-determination, and that there are 3 main objectives that the people need to meet. And I think this was from Jajaman from the Western Sahara case that you quoted this, that the objective that there is an objective characteristic of these people, which is a distinct language, culture, religion, etc. But there are some subjective factors like their conscious action to want to. And the third was a relationship to a defined territory. And for the Tamils, it is the northern and eastern parts of the island nation of Sri Lanka. And so meeting all of these 3 elements that were outlined by Judge Aman from the Western Sahara case, he went on to give some examples of remedial secession and examples of successful cases, and spoke of some of the difficulties as well, just like David Matas had later on, of some cases. You spoke of the Arlen Island, the Congo, Greece, Quebec, Southern Cameroon, and Kosovo. And if I may put words in your mouth and big, huge summary of all of those examples, was the recurrent pattern of 2 criteria. And that was that, the oversimplification, of course, that 1, gross or egregious violation of human rights of the peoples, and 2nd, their inability to meaningfully participate in the governance of that nation that they are part of. And again, in your final answer that you gave to one of the questions, you reiterated the conditions that needed to be met for successful remedial secession is that it be aligned with a big power, that the claim should be consistent with the prevailing norms, have support of international NGOs, and that the oppressor state should be politically and economically weak. And you mentioned that the conditions right now for Tamils is actually quite favorable to be able to be successful in our claims towards or our movement towards remedial secession. Then we had Professor Alfred Desayas join us, and he spoke of that there's absolutely no question that the Tamils have the right to remedial secession, but the fact that it's not self-executing and it's not automatic is probably the biggest problem for Tamils. And the fact that it is really a political matter, and that there were so many examples, many of the examples that Mr. Rudrakumaran had mentioned, Professor Desayas also touched on, added on the Bubiza Palestinians, Equatorial Guinea, and the Yoko people, the Mambuchis of Chile, and many other examples, and spoke of many examples of peoples who were not successful and why they were not successful, and spoke of the usefulness of the rights, and that the idea of remedial secession and how they work together to actually achieve self-determination. And his main argument that I took away was that it needs to be backed up by political will in order to be able to make it happen in a real way. He spoke of UN Charter Article 39, which is the determination that a situation constitutes a threat or a breach of international security, and the unjust denial of self-determination is a threat of international security, and said that that is maybe one avenue for us to approach. He did mention his book where he spoke of 25 principles. I believe the number is 25 principles to focus on. And the final thoughts, if I may, of Professor Desayas was that one stronger claim that we have a stronger claim than the right to remedial secession is a claim based on human dignity, that all peoples have the right to self-determination. 2, that paragraph 3, all state parties have an obligation to promote the realization of the right to self-determination, and the fact that all signatories are supposed to actually proactively promote this right to self-determination. And clearly that's not what's happening today. And finally, he spoke of paragraph 80 from the Kosovo decision, I believe it was, that we cannot use the principle of territorial integrity to frustrate another internal group of peoples. So moving on really briefly and quickly to David Matas, who helped, and I think had a holistic conversation, being able to be our latter speaker, and add on to and strengthen the arguments that many others had made, many of the preceding speakers had made, that the precedents that were set by the Arlen Islands, Zaire and the Katanga people, Cyprus, Quebec and Canada and Kosovo, all of those precedents can really help us build our case today. We should not only look at the successful cases of remedial secession and successful remedial secession through self-determination, but we should also look at the no's and learn from what were the thresholds that would have meant that those could have been a yes. And again, there was an overabundance of repetition in the fact that there were 2 things. One is egregious violations of human rights, and the second was the inability to participate in a meaningful way in the political process. And David also pointed out from, I believe it was the Kosovo case through the International Court of Justice advisory opinion and Judge Yusuf's comments, that there was a third element that we need to maybe look at, and that is that you must actually exhaust all domestic remedies before you can actually qualify for the international law to apply. And in that case, the Tamil situation, we have a plethora of international reports declaring that the local remedies have in fact been exhausted and could be utilizing the international jurisdiction at this point. So the fact of the matter that Sri Lanka on the ground and how they treat the Tamil people really does allow for this international jurisdiction to be applied based on the fact that A, continued violations of human rights, plethora of evidence to that, whether it's empirical evidence that can be made available or already documented international reports. Two, the inability to participate meaningfully in the political process in Sri Lanka. And we heard this from all of the speakers, that the Tamils can elect their own members of parliament on the island nation of Sri Lanka to participate in that house of legislature. However, they cannot make a meaningful impact, cannot actually alter the course of any legislation that is put forward, just because of the fact that there's such a small minority of representatives in the House of Legislature. And three, Tamils have exhausted all domestic options in Sri Lanka, and thus we really do qualify for the usage of the international jurisdiction. Doctor, I'm not sure if you've completed your doctorate or if you're ABC right now, all but your dissertation right now. I don't know what's going on, but Mr. Pettam, professor, I think, had spoke of the improper decolonization, just like Professor Desai said as well. And we should maybe look at the fact that the state nation of Sri Lanka, as it was created through the decolonization process, was not created properly. And that is a completely another avenue that we have available to us, is the improper decolonization of Sri Lanka. And the example of Mauritius was one that was spoken a few times by both of the speakers. And the fact that this improper decolonization, the fact that the integrity of the domestic nations, really, the kingdoms that existed on the island when the British colonization happened and the amalgamation of the peoples happened by the British, and then when they decolonized, that the decolonization was done in an improper manner. And Professor Desai also provided some legal examples and statutes or articles that we should look to lean on, which I didn't catch all of them, but they are mentioned in his book in one of the chapters. Bosco, I want to lean on some of the comments that Bosco made and how we can actually utilize the third and fourth committees of the United Nations mechanism, use the existing framework and mechanisms as our entrance point, because the fourth committee is the committee in which many nation states, I believe, Bosco, you said approximately 84 countries have been able to successfully gain their independence from the work that started from the fourth committee. So instead of trying to go straight to the General Assembly and saying, all right, let's do this, everybody, why don't we focus on the fourth committee, who has the purview specifically in working with this, that we can actually work with the fourth committee, and it should be easier to get member states to come on board. And the example that Bosco shared was Venezuela, who is not yet willing to commit at the General Assembly level, but is willing to commit at the fourth committee. And if we can get the work started in a meaningful way at the fourth committee and get the fourth committee on board, we could also be getting a special prosecutor involved. There's so many mechanisms available through the United Nations. And my point that I walk away with is that we, as a diaspora community of Tamils who want to continue this work, who care or are passionate about it, need to be working in as a collective, in a way that we are working to support one another and leverage one another in the work that we're doing. Another avenue that's available, the decolonization apologies, is the third committee. The fourth committee, fourth committee is Special Committee on Decolonization. And also available to all of us is the contact information for His Excellency Mohammed Siad Duale, the permanent representative of Djibouti to the United Nations. Bosco provided his contact information for all of us and any of us to send our comments. So maybe they would actually start an investigation and get this process started. I apologize if it took a little bit longer than I was hoping for. Vima, let me know if I've left anything out that is
you did a good job. You did a good job.
Thank you for trusting me to summarize what these brilliant minds had shared with us today. And thank you, everybody, for all your contributions. David, great to see you again.
Excellent. Thank you very much, Ratika Sitchapayisan. Shardi, that we can conclude the meeting because we already passed almost 3 hours.
Oh, yeah, for sure. Well, we've had a lot of information that's just been thrown at all of us. So I really encourage those who took notes to reflect upon them, to think back upon this discussion and really reflect on what we can do after hearing all of this. What's the next steps that we can take? And we've had a lot of great minds really come together to share their knowledge with us. We had Ratika give an amazing summary of all of the points that were given to us that were made. And so I hope that everyone enjoys the rest of your day wherever you are in the world. Please stay safe, and we hope to see you at our next meeting about Eelam Tamil's right to self-determination. Thank you. My name is Sharathi Ramesh, and I would like to also thank ABC Tamil Oli for hosting this event. As always, thank you, Vimal, for your introduction and for helping with the hosting of this event as well. And we hope to see you all soon. Thank you. Nandri.
நன்றி. வணக்கம் அனைவருக்கும். வாழ்த்துக்கள் கூறி விடைபெற்றுக் கொள்வோம். அந்த வகையில் நாங்கள் எல்லோரும் இந்த விடப்புறம் வந்து ஒரு விடயத்தை நான் இங்கே அனுத்திரமாக குறிப்பிட விரும்புகின்றேன். அதாவது ஈழத் தமிழர்கள் ஆகிய எமக்கு நம்மை நாமே ஆளக்கூடிய சுய நிர்ணய உரிமைக்கு உரித்தானவர்கள். அந்த வகையில் ஈழத்தில் படுகொலை செய்யப்பட்ட, இன அழிப்பு செய்யப்பட்ட எமது உறவுகளுக்கும், காணாமலாக்கப்பட்ட எமது உறவுகளுக்கும், போர்க்குற்றத்தினால் பாதிக்கப்பட்ட எமது உறவுகளுக்கும் செல்வன் பாலச்சந்திரன் கொலைக்கான நீதி முன்னிலைப்படுத்தி எமது செயற்பாட்டை முன்னெடுக்கும் அதே நேரத்தில் எம்முடைய சுயநிர்ணய உரிமைக்கான போராட்டத்தினை முன்னெடுக்க வேண்டும் என்று எல்லோருடையும் கூறிக்கொண்டு உங்களிடமிருந்து விடைபெற்றுக் கொள்கின்றேன். நன்றி, வணக்கம்.